A letter reached me a few months after I sentenced him. It was not from the defendant. It was from the man he had stolen from. One sentence in it said, he stayed after the tool drive ended and sharpened every donated shovel before he locked the gate. I read that sentence twice. I want to tell you how we got there. When the case first came across my bench, it did not look like a story with room in it. It looked like a break-in at a small auto shop on the south side of San Antonio, a stack of repair estimates, a list of missing tools, and a plea offer the state thought any sensible defendant would take. He rejected that offer. He did it with his chin up, his answers clipped short, and a kind of stiffness that made almost everyone in the room decide he was arrogant before a witness was sworn. I did not agree yet. I had only seen paper. Paper is never the whole person. Subscribe before I go further. Cases like this one do not happen as often as they should, and they deserve to be documented and heard the same way the harder ones do. Subscribe so you are here when I get to the part that made me remember why I chose this work. His name was Daniel Reyes. He was 27 years old, and when he walked into my courtroom on Monday, January 12, 2026, he looked like a man trying very hard not to look afraid. He wore a pale blue shirt that still had a fold mark pressed into one sleeve, like someone bought it in a hurry and handed it to him that morning. His right knuckle was split and healing. He kept taking his plea papers, folding them into neat thirds, then flattening them again with the side of his hand. Before he sat down, he pulled a chair out for his mother without looking at her. I noticed that. I am careful with first impressions because shame can look rude from 40 feet away. Fear can look proud. People who have run out of ways to hold themselves together often come into court wearing the wrong face. I am not saying Daniel came in gentle, he did not. I am saying I had not yet earned the right to mistake his posture for his character, not that early. The man he hurt was Ruben Garza, owner of Mission Street Auto and Tire at 3418 South Zarzamora Street. Ruben was 58. He carried his papers in a worn brown expanding file and kept his reading glasses tucked into his shirt pocket. When he came in, he did not rush. He moved like a man used to lifting heavy things for a living and seeing no reason to waste motion. What struck me first was not anger. It was order. His notes were written in block letters. His invoices were clipped by date. He had come prepared to tell the truth without decorating it. And what he needed from that courtroom was not what many people assume a victim needs. He did not need me to perform anger for him. He did not need the longest sentence available just so the room could feel severe. When he testified, he said, "Judge, I need him to understand what a missing toolbox means on a Monday morning." That sentence stayed with me because it was precise. He was not talking only about metal drawers and socket sets. He was talking about lost work, delayed repairs, and the plain fact that other people's days had been bent around one man's bad choice. The incident happened on Friday, November 14, 2025, at 10:43 p.m. Daniel had worked at Ruben's shop on and off for 11 months before being let go 6 weeks earlier. That night he came back in a white 2004 Ford F-150 with a cracked left taillight. He cut the side chain on the gate with bolt cutters, forced the gate open wide enough to pull out a red rolling toolbox, and loaded 2 impact wrenches, 3 socket rails, and a battery charger into the truck bed. In the process, he bent the lower gate track hard enough to throw it offline. When Ruben arrived after the alarm alert hit his phone, he found Daniel halfway through loading. Ruben said his name. Daniel turned and said, "I'm taking what I need to work." That sentence mattered because it held 2 truths at once. He was stealing. He also believed, or wanted to believe, that need had made the theft less real. It had not. A person can be desperate and still wrong. A person can be wrong and still be fully human. From the bench, my duty is to hold both truths without letting either one swallow the other. The losses were concrete. Ruben's shop lost $3,870 in unrecovered tools and $640 in gate damage. His Saturday crew lost time because one service bay was out of order and another had to borrow equipment from a nearby shop. He also lost something harder to invoice. He had built a place where men could work, sweep up, lock the gate, and go home. Daniel brought fear into that place after hours. That harm was real too. There was context, and context is not an excuse. Daniel had been sleeping in his truck or on a friend's couch. His drinking had gotten worse after he lost the job. He had drifted from the people who could have checked him because being seen by them had become painful. When he testified, he said, "I had been sleeping in my truck for 9 days." He did not say it to invite pity. He said it like a fact he was tired of carrying alone. Subscribe before I keep going. I made a choice in this case that I want to explain fully. Subscribe now. Because the reason I made it is coming and I want you to be here for the whole explanation. In Texas, when a defendant rejects a plea offer and enters what people call an open plea, punishment comes to the judge. That does not mean I am free to ignore the law. It means I am responsible for using every lawful tool inside it. In this case, the tool that mattered was deferred adjudication. If I were explaining it at a kitchen table, I would say it this way. The law lets me, in some cases, hold back a final finding of guilt and place a person under strict conditions instead. If they do the work, they can leave with more of a future than a blunt sentence would leave them. If they fail, the consequences are still there. It is not a soft option. It is a more exact one. The case file told me the offense, the value, the damage, and the state's recommendation. What it did not tell me yet was whether Daniel was asking for escape or whether he was ready for obligation. That difference matters to me. Anyone can want relief. Not everyone is prepared to carry structure. From the bench, I watched both men enter the room before punishment began. Daniel came in too early and stood at counsel table with both hands flat on the wood, as if he needed the table to keep him steady. He never once looked toward the prosecutor. He looked twice toward the gallery, once at his mother and once at the empty seat where Reuben would sit. Reuben entered a few minutes later and placed his file near the rail. Daniel moved his own paper cup a few inches to make room for it. No one told him to. From where I sat, I saw that small motion. Most of the room would have missed it. Turn one came to me in a letter. It was not from Daniel. It was from Teresa Garza, Reuben's wife. She was not required to write anything. Her note was 6 sentences long, and one line in it changed the way I read every page that followed. She said, "Before he turned into this version of himself, Daniel was the one who stayed late to sweep Bay 2 when my husband's knees were hurting." That sentence did not erase the burglary. It did something more useful. It told me the man on my docket had once known how to help in the exact place he later harmed. Once I had that sentence, I read the rest of the case differently. His rejection of the plea deal no longer looked to me like pure defiance. It looked like a man who may have understood, however badly he expressed it, that a short jail sentence and a final conviction would likely close the last decent work door still cracked open in front of him. That did not mean I owed him rescue. It meant I needed to keep looking. The first witness, after Reuben, was Miguel Torres, the shop foreman. He was not there to defend Daniel. If anything, he had more reason than most to be hard on him. He had supervised him, warned him, and once pushed to have him fired. But when I asked about the whole picture, Miguel said, when a single mom came in with a bad tire and said she could pay next week, Daniel was the one who said, "Put it on my tab." He said it flatly, no theater. That was the first time the case stopped being only a file and became a person sitting in front of me. The prosecutor did his job well. He reminded me Daniel had not gone back in daylight to ask for work or help. He had gone at night with bolt cutters. He reminded me Reuben had come face to face with a former employee in the dark and had every right to feel unsafe. He reminded me that a man who looks trapped can still be dangerous. He was right to say all of it. I needed the full weight of the harm in the room, or any mercy I gave later would be careless. Then came turn 2. During a recess, I used my discretion to let the defense supplement the record with treatment and employment information. That is a plain phrase for something important. It means I chose not to sentence this man based on guesswork when the law allowed me to ask for the missing facts. When court resumed, defense counsel handed up a black binder with attendance sheets from an outpatient alcohol treatment program, 23 clean tests between November 28th and January 9th, a completion certificate dated December 22, 2025, and a letter offering Daniel a probationary electrical apprentice position beginning February 2nd if he remained sober and legally available to work. That binder mattered because it showed me not only who he had been, but what he might actually be able to sustain. Not imagined change, documented effort, dates, signatures, tests, an employer willing to risk a start date on him. Evidence like that does not ask me to feel something. It asks me to decide whether the law can make room for a future the facts now support. I watched the room when the binder was handed up. Daniel did not look at it. He looked at the floor. His mother pressed a tissue against her mouth. Reuben uncrossed his arms and set his pen down. The prosecutor stopped writing and read the treatment dates a second time. Nobody announced the shift. I could see it anyway. Subscribe before I continue. I have been building to something in this story, and it is not where you might think it is going. Subscribe and let me get there. The defense made one argument that helped Daniel because it was honest. Counsel said, "Judge, if you send him home with nothing but good wishes, you will see him again. He needs rails, not air." I respected that. It told me the defense understood the difference between mercy and looseness, but he also tried, at first, to treat the bent gate like a side detail. I would not allow that. A broken gate at a small shop is not a side detail. It is the place where security failed. It is part of the injury. When I said so, he adjusted, and I appreciated that too. Then Daniel testified. He was not polished. He did not sound rehearsed. The prosecutor asked why he had not gone back during the day if he truly needed work tools. Daniel said, "Because in the daytime, I would have had to look him in the face." That was not self-protection. That was admission. It told me he knew exactly what kind of wrong he was committing. Later, his own lawyer asked him what he had really taken that night. Daniel looked at Reuben and said, "I took from a man who had trusted me. That is on me." I hear a lot of apologies from people standing where he stood. Many of them are aimed at the sentence. This one was aimed at the truth. There is a difference. I could hear it. Then came the sentence I wrote down. His lawyer asked what would make any plan work this time when other plans had failed. Daniel said, "I do better when somebody is counting on me at 6 in the morning." That was the moment I knew what I was going to do. I wrote it down. Not because I needed to remember it, because I wanted to. That sentence told me what structure had to be built around if I was going to choose the lower end of the lawful range. When he said that, an old scene came back to me. I was 12 years old, standing on a neighbor's porch in July with a covered bowl my mother had sent next door. The porch light was yellow. The screen door had a tear near the bottom. Mr. Villarreal sat in a metal chair holding an invoice for copper wire his son had taken from a work site. He was not defending the boy. He was trying to understand how hands taught to work had ended up taking from another worker. I remember the sound of cicadas and the bowl cooling in my hands while he said, mostly to himself, "He is better when somebody expects him early." I did not explain that memory in court. I just let it stand next to Daniel's words. Subscribe. Because if this case surprised me, and it did more than once, I think what comes next will do the same for you. Subscribe and stay with it. Reuben helped me again before sentencing, though I do not think he knew it. He said, "I am not asking you to bury him. I am asking you to make him carry this the right way." That was one of the clearest things anyone said all day. It told me what accountability meant to the person most entitled to speak about it. Not easy, not vague, not empty suffering. Carry it the right way. By then I had what I needed for turn 3. The third turn was sentencing itself. That is where a judge's belief becomes structure or it does not become anything at all. I had made the decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. I looked at Daniel. I looked at Reuben. I looked once at the gallery where Daniel's mother sat with both hands around her purse strap. Then I announced the sentence. Subscribe. I have not told you the full sentence yet. I am about to. Subscribe before I do because I want to explain every part of it, and the explanation is as important as the ruling itself. Subscribe now. I said, "Mr. Reyes, I am placing you on deferred adjudication community supervision for 18 months. Then I told him why. I was choosing the lowest end of what the law allowed me to choose while still treating the offense with full seriousness. I was not doing that because he had earned a free pass. I was doing it because the evidence gave me a lawful reason to build a future-facing sentence instead of a blunt one. I said, I am ordering you to pay restitution in the amount of $4,510 to Ruben Garza and Mission Street Auto and Tire through the clerk's office, with a minimum payment of $100 every Friday, beginning with your first full paycheck. Then I explained it. Money cannot repair trust, but it can restore the exact loss he caused. If the harm was specific, the repayment had to be specific too. I said, I am also ordering you to maintain full-time employment or a full-time apprenticeship and to complete 26 weeks of outpatient alcohol counseling with no unexcused absences. Then I explained that too. Work was the straightest line left in his life. Alcohol had been eating through it. If I ignored either one, I would be pretending not to understand the case in front of me. Then I gave the part of the sentence that mattered most to me. I said, and there is one more thing. You will complete 160 hours of restorative service at the Westside Community Tool Bank. You will clean, sort, repair, and prepare donated tools for people who need them to work. If Mr. Garza agrees, 12 of those Saturdays may be completed at community repair clinics held in his parking lot, on his terms, not yours. I wanted his hands doing the opposite of what they had done that night. I also ordered a relational condition. I said, for the first 12 months, you will meet twice each month with your approved mentor, Arturo Reyes, and you will complete 12 Saturdays with the wheelchair ramp build crew he supervises. I did that because people who say they do better when someone is counting on them should not be left alone to prove it in theory. I built being counted on into the sentence itself. Then I gave him a benchmark. I said, if by day 270 you have paid restitution in full, completed at least 13 weeks of treatment, missed no tests, and finished 100 service hours, I will set a review and consider reducing supervision from 18 months to 12. That was my way of placing belief where a calendar could test it. Then I said what I needed him to hear. I said, what you did brought theft and fear into a man's place of work. Mr. Garza and his crew paid for your night with their money, their time, and their peace. I am not minimizing that. Then I said the other truth. But the charges on this file do not contain all of you. They do not contain the part that can work, repair, and be counted on. I believe you can do this. I wanted that belief stated plainly. I ended with one sentence addressed to him as a person, not a case. I said, Mr. Reyes, become the man people can safely hand tools to again. The first reaction I noticed was Ruben's. He reached into his file, pulled out a business card, and held it between two fingers until the deputies cleared the aisle. Then he stepped toward defense counsel, passed the card down, and said, Monday, 6:30, don't be late. Daniel did not answer right away. He nodded once and put the card in his shirt pocket. Subscribe. I'm about to tell you what happened after the sentence, whether this person did what I believed he would do. Subscribe so you are here for that part. It is the part I care about most. Courtroom promises are easy to make before lunch. Life tests them by Tuesday. Daniel reported to probation on time. He started the electrical apprenticeship on February 2, 2026. He made his first $100 restitution payment on Friday, February 6th. The next Monday he showed up at Ruben's shop at 6:27 a.m. and, according to both men later, said very little for the first hour. He swept, sorted sockets, and listened. The specific thing I carry happened on Saturday, March 14th, 2026. The Westside Community Tool Bank held a neighborhood tool drive that day. Later I learned, through a progress update and then Ruben's letter, that after the folding tables were put away and most people had gone home, Daniel stayed behind and sharpened every donated shovel before he locked the gate. That is the image I opened with. It is small. It is enough. No appeal was filed. I will tell you honestly what that meant to me. It meant the people who knew the case best understood the sentence as a lawful answer to what had happened, even with all its demands. Not the only answer, but a sound one. What I have come to believe is simple. The hardest form of mercy is the kind that can be checked against a calendar. Anyone can speak gently. It takes more to write dates, payments, tests, hours, and obligations into an order and then stand behind it. It would have been easier, in one sense, to impose a short, blunt sentence and move on. Blunt sentences are quick. Precise ones ask more from the judge, too. They ask for attention. They ask for courage. They ask me to know exactly what I am requiring and why. This case gave something back to me, not as a judge, but as a person. It gave me back a little trust in slow work. If you have been where Daniel was, having done real harm and wondering whether any path forward still exists, listen carefully. The thing I look for from the bench is specificity, not polished regret, specific truth. Name what you did. Name who paid for it. Name what you have already started doing before the court rewards you for it. Then keep doing it long enough that your actions stop needing a speech. And if you have been where Reuben was, asked whether mercy for someone who hurt you is even something you want, I will not tell you what to want. That belongs to you. I can only tell you what I have witnessed. When victims choose a form of accountability tied to repair instead of only pain, it often gives them back a little authorship over what happens next. Not control over everything, not peace on command, just a say. Later, after months of compliance, Reuben sent one more short note. He said, "He kept every promise you wrote down. I have carried that sentence with me, too. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you leave a comment, leave it like you are stepping into a room where people understand that justice and humanity are not opposites, and where careful words still matter."